Today I want to talk to you guys about what happens once you go to small claims court with a creditor and you lose out and you get a judgment. The ins and outs of what happens after a judgment is rendered, how they're able to collect the money, and how long, obviously, a judgment will stay on your credit report, and some of the do's and the don'ts concerning that. Hey, I wanted to jump in right now and tell you guys not to forget down below to check out my free letter bundle. You'll get 4 letters absolutely free to help you on your credit journey. There's a pay to delete, a goodwill letter, a cease and desist letter, as well as a debt validation letter. That's to help you out on your journey. Be sure to check that out in the description down below. First of all, thank you for clicking on this video. If you do have a judgment, it's not the end of the world. We all go through tough times. We all go through hard times. And this video is to sort of kind of inform you on the do's and the don'ts and what can possibly happen once you actually do get a judgment. Now, if you get a judgment on your record, you go to small claims court, you try and fight the creditor or the debt collection agency, and you lose out and you get a judgment on your record. The first thing that I would recommend that you do is you try and pay them voluntarily. The reason why I say that is because, you don't want your wages garnished, you don't want, a bank levy, you don't want, a tilt tap, you don't want some of these things to happen. And if you can pay them voluntarily, most likely they'll accept a voluntary payment. But to be honest with you, most creditors, especially debt collection agencies, made sure that the person worked or they had assets. Now, the next thing I want to talk about is if you don't pay voluntarily, what can they do? And I'm going to explain to you some of the options that they have with regards to getting the funds from you involuntarily. Number one, they can do a bank levy. So basically what a bank levy is, let's say you owe $3,500. And you had a bank account that they had access to. They knew that you banked with Chase Bank, for instance. They can actually levy the total amount due right out of your bank account, zap it right out of your bank account without you even knowing, or obviously you will know, and once you do know, they can just take it and that's that. A second thing that they can do is garnish your wages. Now, in every state, it varies, it's different. I think in the state of California, they can garnish your wages up to 25% of whatever it is that you're making. So, obviously, if you're making $1,000 a week, they can possibly take $250 from you until, obviously, the fees are paid back. Now, understand, when you get a judgment, you're going to owe the full amount plus any interest and a lot of times court and attorney fees. Another thing that they can do is they can place a lien on your property. If you try and sell the home or get rid of the home, that creditor, you would have to actually pay that creditor before you can actually sell it, refinance your home, and do a lot of things to the home. So that's another thing that they can do. And one of the other last things that I'll talk about that they can do is what is called a tilt tap. So for those of you who own a business, I remember when I worked at that company, there was a barber that we actually got a judgment against. For whatever reason, he didn't want to pay. And so basically what they did was they sent a sheriff inside of his place of business that he actually owned. And basically that sheriff, any money that came in for that day, that sheriff took it, paid obviously the company that I work for. But once that sheriff came in there, because of the embarrassment, people, customers are coming in, they're wondering what the heck is going on. Immediately, I remember him calling me up. I offered him a settlement. Originally, he didn't want the settlement, and so once we got that tilt tap, when that sheriff went in there, he called me immediately. He ended up having to pay the balance in full. And so those are some of the things or ways that they can get money from you with regards to getting a judgment. This Thursday, I have a free webinar to teach you how to save 30 to 70% off of your debt. Don't forget to register down in the description or in the comment section. A big misconception that people talk about a lot of times is can I go to jail for not paying my debt? I know that there are agencies out there that have threatened, especially with payday loans, saying, it's fraud and that you can go to jail. For not paying an actual debt itself, no, you cannot go to jail. That's a myth. But what can happen is, let's say we got a judgment against you. I went back and got, a writ from the judge to have you come back to court because we weren't able to get the money and we wanted to do an asset investigation against you to try and determine, how we can get the funds from you. Now, you as the consumer, if you got a court date to actually appear, you don't show up to court, a judge can place what is called, I think, a bond, where technically, because you disobeyed the judge from going to court, they can put that out, and if through a regular traffic stop or something like that, you'll end up having to go to jail until you actually do what it is that that judge requested that you can do. So no, for not paying a debt specifically, no, you can't go to jail because you didn't pay a credit card or a payday loan. Another thing, judgments. They can last anywhere from 5 to 20 years. Now let me explain to you. In the state of California, if you have a judgment against you, it can last up to 10 years, right? But within that 10-year time span, before that 10th year date is up, the creditor can go back to court and get a renewal of that judgment for another additional 10 years. So basically for 20 years, you can have a judgment against you if you don't pay it. In conclusion, as a whole, ultimately, if you can pay your debts off before judgment happens, I recommend you do that. Now, obviously, if you can't afford to pay and your situation's tough, then that's the circumstance. But a lot of times creditors don't know. So if you call them up and you let them know like, hey man, my finances and situation is where it's at, a lot of times you can avoid even a judgment happening before it even happens, because you get a judgment on your record. A lot of times creditors, they're not going to go for a judgment unless they know you have some assets or you're working. But sometimes the information may show that you're currently working. You may not be, or you may have stopped working, or whatever the circumstance is, and you still get a judgment that can last up to 20 years. So try and take care of it. If you have any questions, put them down in the comments section. I'll be sure to answer them. As I always say, if you got a judgment, it's okay. Life keeps going on. Figure out a way to get it paid and to get it paid soon. And as always, you be great.